Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about sentencing for impaired driving causing death. Cases that should have gone to the Supreme Court of Canada, but didn't. An individual committed the offense of impaired driving causing death. At her sentencing hearing, she argued that she should be allowed to serve her sentence in the community, effectively pointing to the fact that she didn't pose a continued risk to the public, and that a determination of whether somebody should serve their sentence in the community is typically grounded in whether allowing them to do so would put the public at greater risk. When it comes to impaired driving offenses, by and large, people are not putting the community at greater risk if they have dealt with their alcohol use, if they're on conditions not to use or possess alcohol, and if they have driving prohibitions, all of which typically come with a conditional sentence or a house arrest order. And so this was the perfect opportunity for the Supreme Court of Canada to really get into the way in which a CSO must be considered in the context of protection of the public versus the jail sentence issue. We know that this is the test, but there have been very few cases that have actually talked about what protection of the public looks like and how judges should assess that, especially in the context of offenses that are more like absolute liability offenses like impaired operation. In the circumstances, the court missed the opportunity to comment on it. And although this individual did ultimately get her sentence varied to be a conditional sentence from the appellate court, it would still have been nice for the Supreme Court of Canada to give a binding guidance to all judges across the country. We know these are serious offenses that have a serious impact on the community and serious consequences for everybody involved, including the police, the perpetrator, and the victim and their family. And so it would be helpful to society as a whole for the Supreme Court of Canada to really chime in on what the specific test is for a CSO in the context of impaired driving offenses and in the context of cases where protection of the public can presumably be managed through the imposition of conditions. Why then would a jail sentence in a traditional form of incarceration, as opposed to a jail sentence served in the community, ever be necessary to deter a first-time offender who commits this offense? Unfortunately, we don't have that guidance from the Supreme Court of Canada, and so sentencing judges are going to continue to have to struggle with the question of when a CSO is appropriate for an impaired driver who kills. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you for watching. Please like, subscribe, and share with your friends.